Hi, I'm Greg Dell here with Steve and Jessup. And Steve, I want to talk to you about a really good case that just came out of the Sixth Circuit Court of Appeals. And it was a case that was appealed up from a Michigan decision in which a claimant lost. And it dealt with the issue of a person that was disabled by fibromyalgia. And Hartford denied the claim, which we see them doing all the time, especially when it comes to fibromyalgia claims. So whenever we get a very positive fibromyalgia decision, it excites me for all of the clients that we have who have fibromyalgia and all the people who call us about fibromyalgia. But what was special or unique about this particular case that can benefit all the people that are suffering with fibromyalgia and have long-term disability?
I think the biggest issue in this in the appeal court when they were looking at what Hartford was trying to require, this idea of objective evidence of the fibromyalgia, but there was an even additional spin on it, what the court referred to as Hartford trying to use a red herring, a distraction taking away from the actual issue. In this particular case, Hartford had 2 file reviews done, and their specializing doctors determined that there was no objective findings of certain conditions like rheumatoid arthritis or lupus and certain other conditions. And based on that, they determined that she wouldn't be disabled from the fibromyalgia. And the court said, well, it's established in the Sixth Circuit especially that you can't really require objective evidence of fibromyalgia, and a lot of this testing that comes back normal is purely for the standpoint of ruling out those conditions. And the court reprimanded Hartford's doctors in the way they did the review by saying that they determined she wasn't disabled from conditions she doesn't have, but they never actually did an evaluation to determine if her fibromyalgia was actually disabling. So it's kind of a nuance of it, but Hartford and a lot of other insurance companies do that a lot, where they say there's just a lack of any evidence, and they say you don't have this condition, that condition, without ever really addressing how the fibromyalgia is affecting the person.
Yeah, well, what we're seeing and what goes on all the time, and it's really, it's insulting. And what it is these doctors do these file reviews and they figure, I'm a doctor, these other people are civilians, they don't know anything, so we're going to make up a bunch of garbage and make it look like it makes medical sense. Like, well, even though it's fibromyalgia and we know as doctors there's no objective evidence of fibromyalgia, let's talk about these other things and say you don't have this, you don't have that, which of course you would not have if you have fibromyalgia. It will sound official, we'll send it in. The insurance companies don't know anything because they believe whatever the doctors tell them that they hire, and then they use that to deny it. And they hope that the claimant will get that and go away. And it's borderline fraud. And these doctors who do these what I call hole-in-the-wall doctors, do these paper reviews for $400, should be ashamed for what they're doing. But the courts aren't falling for it. And that's to me, that's the best part about it. But did the court really just come right out and say there's not going to be objective evidence of fibromyalgia?
More or less, in a lot of ways, and they even discussed the tender points and those types of evaluations. But they were clear and even established, reiterated in the case law in that district that you can't require objective evidence. There is no objective evidence of it, so it's wrong for the insurance companies to do it. So, typically you don't think of necessarily the Midwest being very kind of forward thinking and things like this, but this is very favorable for insureds fall in the 6th district, and hopefully more courts will start to adopt that type of rationale and reasoning when they're even reviewing in those various courts.
Right, and we're starting to see a trend. I mean, we handle cases all over the country, and there's federal courts all throughout, and the circuit courts cover groups of states all throughout the country, but we're starting to see this trend more so in the favor of the courts really understanding fibromyalgia and no objective evidence, and it becoming beneficial for these claimants in all of the circuits. But this case was the Sixth Circuit, and that happens to be a very liberal circuit, a very good place for claimants to bring their claims. So it's going to vary a little bit all over the country, but with fibromyalgia, I really feel like the claimants are starting to get the upper hand and that they're going to have the benefit of the doubt moving forward. One caveat to that. This particular individual in this case had very strong doctor support, had a very good appeal done. There's plenty of times people call us and they don't have a good appeal, and we're stuck as lawyers in litigation with the evidence that you give us. So the only reason I bring that up is because when you call us and we discuss your claim's only going to be as good as the appeal that was submitted and a reflection of how badly the disability insurance company reviewed your claim. So call any of our lawyers for a free consultation. We can help you anywhere in the country, and we look forward to the opportunity to speak with you.